Good morning, everyone. Is my mic on? Yes, everyone can hear me? Yes. Okay, terrific. Welcome, everyone. My name is Wes Powell. I'm a partner at Willkie Farr & Gallagher here in New York. And I'm not an academic in any sense, so I was very flattered to be asked to come moderate this panel today of our next generation of antitrust and privacy scholars. So it's my pleasure to welcome all of you here today. And it's hard to find a more current or compelling topic, I think, for an ABA panel program than the intersection of competition and privacy law in digital markets. And the topic and the papers you're going to be hearing about today, and hopefully many of you have read them, tee up a number of hotly debated, much discussed issues and considerations, including does competition law have a role in regulating big data, or in the parlance of our first paper, of concealed data practices? And if so, is competition law really up to the task of that? Secondly, how does this set of questions differ by jurisdiction, where not just the legal rubrics are different, but in many instances, basic considerations of the values of privacy and the like may be different. Taking, for example, China, where our second author will tell us how privacy and antitrust intersect in China, and the sort of differences in terms of the prevailing view of privacy versus the government, or privacy versus private economic actors. And then finally, we have the question of whether privacy laws, and particularly data protection laws, can have unintended consequences of perhaps even enhancing market power and creating competition problems. So we have a terrific panel today to engage on those topics, and it's my pleasure to introduce them. And I'm going to start with with our overall discussion, Jay Hyams, who's known to many people here, I know. He's the co-chair of the Antitrust and Competition Practice at Labaton Suchero here in New York. Before that, among other things he's done with his career, he led the New York State Attorney General's Office Antitrust Bureau for about 8 years. And particularly relevant to this discussion of the digital world, Jay was really one of the leaders of the negotiations with Microsoft in 2001 that led to the conclusion of the governmental monopolization claims against Microsoft. And he also served as the court-appointed monitoring trustee following the DOJ's injunction of the Bazaarvoice merger, which you may recall was a post-closing challenge by the Department of Justice of the merger of two online rating review platforms. So he knows these digital issues well, and we look forward to his contribution today. So I'm going to introduce, I think that to kick things off, I will just introduce our panelists by panel and let them get going. Our first panel concerns an article called Concealed Data Practices, Competition Law, Why Privacy Matters. And the author of this very interesting paper is Dr. Catherine Kemp, who is a senior lecturer at the Faculty of Law at the University of New South Wales in Sydney. She researches in the area of competition law, consumer protection, data privacy, and financial services. She's widely published on those matters, and very interestingly, she's the co-leader of a research project at the UNSW Business School called Data as a Source of Market Power. And she has also private practice experience as a barrister in Melbourne. And she's going to be discussing her paper with Professor Kathy Strandberg, whose name is misspelled on the card, I regret to tell you. And she teaches at NYU Law School. She's the Engelberg Professor of Law there. She teaches and researches on law and technology, including information privacy implications of AI and predictive algorithms, relevant to our prior panel. And if her background as a lawyer and a law professor isn't impressive enough for you, she's also a physicist, for heaven's sakes. She has a PhD in physics from Cornell University, and she taught physics for a time at Northwestern. And with that, I'm going to hand it over to Professor Kemp, and I think who will speak around 10 or so minutes, and then we'll let Professor Strandberg respond. What's that?
Good morning, everybody, and thanks very much for that warm welcome on my first ever visit to New York. According to the hotel that I'm staying at, I'm apparently staying in the soul of Greenwich Village. Last night, though, I discovered an activity that's not listed in the Lonely Planet guide for the soul of Greenwich Village. I managed to access the website of Adobe Brokerage Services and have a look at the health audiences that Adobe offers access to for various companies. I thought you might be interested in the names of some of these lists of health audiences that you can contact via Adobe. Some of them are fairly straightforward: memory loss, trouble walking, visit doctor often, addiction services. I treat myself to foods not good for me. Period pain, PMS, diabetes monitor. Some of them become quite euphemistic. For example, future prospects to experience poor health, not a quality trajectory. And perhaps the most euphemistic is elite receptives, open to most healthcare messaging. I think that's another way of saying suckers list. In any case, the individuals on these lists, I think we'd agree, would largely be surprised, if not shocked, to find that they were a part of a list that could be bought and sold in this way, and that could be used to their distinct disadvantage, as we'll come back to later. This is on the back of reports last week from the Norwegian Consumer Council, which revealed that various very popular dating apps were sharing information, including sexual orientation, sexual preferences, drug use, and political views, with a variety of other third-party vendors, in most cases without any knowledge on the part of the users of those apps. This in turn builds on reports that we've had from regulators and investigations around the world over the last year, including in Germany, the Bundeskartellamt's investigation into Facebook's data practices. In Australia, the Australian Competition and Consumer Commission's investigation into digital platforms, colloquially known as the Google Facebook inquiry, the Furman report in the UK, the Stigler Centre report in the US, and of course we see now investigations potentially by your state attorneys general and the FTC and the DOJ. Most of us would concede that the issues examined by these reports and investigations, the issues of the power exerted by many of the companies and particularly digital platforms in this space, and the data practices of these companies raise issues for consumer protection and data privacy regulation. A somewhat more contentious question is, does this have anything to do with antitrust? Are these issues that need to be taken into account in competition law assessments? My short answer to this question is yes. I argue that the degradation of consumer data privacy in the digital environment causes objective detriment to consumers and undermines the competitive process, and should therefore be of keen concern to competition regulators. I should qualify that by saying I'm not arguing that competition law should be the primary mechanism by which we deal with these issues. But if our concern, if our objective is consumer welfare, these are matters that cannot be ignored simply because they are not easily measured. To get to that point, let me first address two contrary views to mine. First, perhaps the most hands-off approach to this issue, which is the view that these are matters of subjective preference. This is a matter for individual bargains between the consumer concerned and the companies they deal with. They each have their own subjective privacy preferences, and these are non-economic matters that are not rightly within the domain of antitrust or competition law. As to those individual bargains, in my paper itself, I go in some detail into examining the way that privacy policies mediate these supposed bargains. For our purposes, we must be a lot more brief at this moment and consider simply this. The privacy policies which various companies publish are meant to document that bargain between the company and the individual. At present, they fail to do this, and they fail abysmally. They lack the information required, and in many cases are simply used as a marketing opportunity. To convey that point, I have an illustration that takes a situation where we're used to receiving information and instead phrases it in privacy policy terms, particularly nutritional information. If you imagined, instead of looking at the side of your box of breakfast bars and being able to see what they contained in terms of fat, carbohydrates and the like, and instead saw privacy policy language which explained that your health is very important to us, we understand that you are trusting us with your well-being, we take that seriously, and we take reasonable steps to provide you with satisfaction in your food choices. Like most snacks suppliers, we may include sweetness to enhance your experience, etc., etc. You're left with no real knowledge of what you're getting yourself into. And that is what we get with privacy policies at present. A lot of permissive language, a lot of persuasive language, but not the kind of information you would need as a consumer to make that decision. Another group of commentators and another view in this respect holds still that we're looking at a bargain between the individual and the company, but according to these commentators, the consumer is probably being underpaid at present. They need more bargaining power. They need a way of achieving essentially a higher price for their data. In this view, it's still regarded as a matter of consumers handing over a certain amount of data and receiving in exchange generally a service of some kind at a zero monetary price. I take issue with this view on the basis that weak data protection and extensive disclosure of our personal data is not a price paid, but a cost imposed on us as consumers. This creates an objective detriment going forward into the future, which is entirely open-ended, as the uses to which our data is put evolve over time, and the terms themselves evolve as companies reserve to themselves the right to amend the terms of the bargain over time. Part of the report last week from the Norwegian Consumer Council was this diagram, which gives you some idea of the data flows from mobile phone apps, some very popular mobile phone apps, They may not necessarily be on your phone. They include Grindr, Tinder, Makeup, Perfect 365, which helps you to get your makeup right 365 days a year, but nonetheless have been used by tens of millions of people around the world. And this gives you some visualization of the flow of personal data from those apps to third-party vendors. This is far from all of the third-party vendors involved that number around 74, but just the most common. What you'll see from that is what most of us as consumers, almost all, almost never see, what we're not aware of, behind the scenes. The effects of this data sharing are not simply matters of subjective preference. Instead, this kind of data sharing causes objective detriments, some of which I'll number now. For a start, the more widely our information is collected and stored, and by more recipients, the greater the attack surface of that information, which means quite simply that the more it's held and the longer it's held, the more likely you are to experience hacking, improper disclosure by the recipients themselves, improper use of that, ID theft, ID fraud. All of that risk increases by the mere increase in collection and storage. Beyond that, there's the increase in disadvantage through the increased risk of exclusion from offers and services and credit on the basis of that information, manipulation-based marketing, which Ryan Calo has explained in great detail, and price discrimination. For example, I was at a fintech conference last year where an insurance company was explaining how they provide Fitbits to their customers to track and monitor their health. I had a question for her. I asked, do you use that data collected from your customers' Fitbits to vary the premiums that you charge to the customers? She said no. She said we only use them to vary the discounts we offer on those premiums. It's a very different thing. All of those disadvantages increase with that sharing of information. Beyond that, there's also the potential for that information to be aggregated with other information and re-identified with seemingly anonymous information previously provided, and used to make inferences about us to reveal information we would never have chosen to reveal in the first place. For example, researchers have been working with data from Microsoft that allows them to examine users' online scrolling and clicking patterns to work out whether they are at risk of developing Parkinson's disease. What seems an innocuous disclosure can either now or in the future be used to our significant disadvantage. These increased risks are objective harms that are a reflection of the degraded quality of the product in question. Now, of course, as I said earlier, this raises consumer protection issues, questions of privacy regulation, but what of antitrust? I've, in this paper, defined a phenomenon that I refer to as concealed data practices. This occurs when suppliers supply their services with weak privacy protections to consumers, where the extent of the terms of their privacy or lack thereof, the resultant data practices and the consequences of those practices are concealed from the consumers themselves. These obscured terms often permit the collection and retention and disclosure of personal information well beyond that which is required for the service and well beyond the reasonable expectations of the consumer. To put this in diagram form, you can tell this is an antitrust cartoon because it has an octopus in it. I outline in the paper a number of competitive effects from concealed data practices, but this diagram demonstrates just one aspect of those competitive effects, and it covers the case of digital platforms in particular. You can imagine here a scenario of a social media platform which is dealing with two distinct groups of customer. In this case, advertisers and the users of the platform themselves. And supposedly serving both of those groups of customers. And in fact, however, as is outlined very adeptly in a paper called Freefall by Kathy Strandberg, these platforms are serving their primary customers being the advertisers themselves, such that the product is designed to extract maximum consumer data and attention for the advertiser's purposes, and therefore it is the advertiser's preferences that are being served. In the process, these concealed data practices extract information which attracts higher advertising revenue from those advertisers, which is in turn used to fund the platform to make it more attractive or sticky for the customers themselves, and the cycle continues. One of the effects that this has in terms of competition is that it makes it very difficult, near impossible, for a privacy-respecting rival to attempt to promote their privacy-enhancing product. As long as those data practices are concealed, it means that the privacy-enhancing rival will never be able to demonstrate the advantage of their product. At the same time, they will never be able to attract the advertising revenue that funds the stickiness of this dominant platform. In this way, the concealed data practices contribute to the maintenance of market power and do so in a way that does not represent superior efficiency on the part of the platform itself. Now, you might rightly say, well, that's not an antitrust contravention at this point. You're not going to be able to establish a monopolisation claim, exclusionary conduct on that basis alone. Nonetheless, there are some aspects and some implications for our competition law assessments, which I've put here in very shorthand terms, and we can cover briefly, but which I would ask you to look at in more detail in the paper itself. Firstly, as competition regulators, we should not be assuming on the basis of revealed preference theory that consumers have signalled a preference for the data privacy terms they are currently offered. There is, of course, a place for revealed preference theory. If I say that I'm vegan and you see, in fact, that I order a quarter pounder with cheese every lunchtime, you can fairly assume that I think animal products are delicious. In this case, however, when the actual terms on which we're provided the service are concealed from the consumer, let alone the practices themselves and the consequences of those practices, it's entirely inappropriate to apply that revealed preference theory to assume that, contrary to the consumer surveys that say that consumers are increasingly concerned about their online privacy, they in fact prefer these degraded privacy protections. Secondly, it will often be the case that competition regulators will need to assess the present state of competition in a market. In assessing the state of competition, we need to focus on tools that can take account of this quality dimension. That won't be a simple matter, especially for those that are attached to the price theoretical approaches, but especially given the increasing prevalence of markets where there is a zero monetary price, we will need to be able to have tools of analysis that can take account of the qualitative aspects, both in terms of the benefits and these degradations in quality. Thirdly, there will be situations, particularly in the case of mergers or exclusionary conduct, where we'll need to consider what is the anti-competitive effect and what is this, how substantial or significant is the anti-competitive effect from certain conduct. I argue that where concealed data practices are already occurring in a market, such that competition on this quality aspect is already diminished, then a relatively small change in competition and a smaller anti-competitive effect may in fact be more significant than in cases where concealed data practices are not present. So, for example, if there was a merger where concealed data practices were already prevalent in the market and the dominant firm was acquiring a small rival which did in fact present the only privacy-enhancing option, then you are more likely to consider that that is a significant effect for those purposes. Finally, there is, in the process of competition regulators undertaking these assessments of the quality of consumer privacy, a beneficial side effect. Commentators have expressed the view that in these areas where highly specialist knowledge and skills are required to interpret the state of affairs, what we need are learned intermediaries who can intercede on the part of consumers and interpret what it is that's on offer. When antitrust authorities in the process of such inquiries investigate the quality of data privacy quality in these markets, that performs this beneficial service as an incidental matter of providing consumers with that information at present. All of this, I should say, is not a solution to the bigger problem of data surveillance and its effects for consumers. These will ultimately be matters of reforming our privacy law and our consumer protection law in some very fundamental ways. But that does not mean that in the meantime we should turn a blind eye to these clear effects on consumer welfare in the antitrust context.
Thank you, Professor Kemp. We'll now hand it over to Kathy to give us some feedback.
Thank you. I really enjoyed reading this paper and appreciated it. I also wanted to thank Wes in his introduction for mentioning my physics background, because perhaps it might have distracted you from the fact that there is absolutely nothing in my background about competition law or antitrust. So I guess now the game is up. I've told you that. And so you'll obviously take my comments on that part of the paper with the appropriate grain of salt. But nonetheless, I'm going to divide my comments up into two main sections, one of which will address Catherine's diagnosis of the problem and of the issue with data practices, and the other of which will raise, most of this is going to be some questions about the competition law aspect of the paper. Okay, so starting with the diagnosis of the harm, I found the concept of concealed data practices, I thought, a very interesting and very useful one, having thought quite a lot about these issues and these concerns myself and read a lot of the literature about it. I think it's very useful to think of it in this way. That said, I just want to raise a few questions about that conception of concealed data practices. So one of the questions that comes to my mind and that really ended up bothering me a lot in the free fall, when I wrote that free fall paper that you already mentioned, is how we should be thinking about this question of whether these data practices are so much concealed or whether they are more opaque, unpredictable, perhaps even unknowable to the entities that are involved in doing them. And by that I mean, particularly to point out, as Catherine is well aware and discusses, the importance of the way that data gets aggregated. And the fact that that kind of aggregation and what can happen as a result of aggregation may be quite unpredictable even to the entities that are engaging in the collection and in the transfer. And so given, I don't know that that affects the diagnosis of concealment, but I would like to know what she sort of thinks about how we think about that. And kind of a similar but less specific to data question is how do we distinguish between concealing and not revealing? So what I mean by that is really basically how do we decide which things need to be revealed and which things don't need to be revealed? And I think this is a very tough question in the data protection area. I like the analogy to the nutrition label, and I've seen people talk about this analogy before. And in fact, there have been attempts by some privacy scholars to make a suggestion that we should adopt something like a nutrition label for privacy policies, or some other way of categorizing and having sort of the simple version of the privacy policy. So in some respects, I think the nutrition label is a great analogy because it gets at something that I have thought about myself and completely agree with the way that Catherine looks at it, which I would maybe use the term kind of the credence good properties of these services where data is being collected. It's impossible for consumers to know what's being collected, what's being done with it, and they're never going to find out no matter how much they use the goods and so on. So that is similar to the issue with nutrition label. You know, you buy something, you eat it, yeah, I guess you can tell if it's really sweet, but it's very hard to have much insight as a consumer into what's inside there. What are the nutritional properties? The difficulty, I think, and I'm not necessarily sure that this is the paper for addressing this question, but it does come up to me, is, okay, that's fine, but when it comes to the nutrition label, we have a fairly good notion of what we should be specifying and how to quantify it and so forth. How do we deal with that with the privacy in the privacy policy area? How do we tell companies what they have to specify? And is there a good way to do that in a nutrition label approach? The next question I wanted to bring up was the question of whether this idea of concealed data practices, what is its relationship to a concept which is kind of coming up and becoming more popular in these discussions, which is the idea of dark patterns. Now, I have to say that I actually was very involved with writing the section of the Stigler report that deals with dark patterns, but before I did that, I had never heard this expression before. So, you know, Leor Strelva says to me, will you do the section on dark patterns? What are dark patterns? But be that as it may, I am now educated. And I think that there is an overlap with these concepts. I'm not sure if they're exactly the same or how they relate, and since there is starting to be some literature on it, I think it might be helpful to engage with that in the paper. And then the last comment I will make about the diagnosis in the paper is, and sort of tossing a hard question that I know is hard to answer. At one point in the paper, you talk about figuring out whether the use and the data and the collection is proportionate to the benefits. I would love to be able to analyze that. I think that's true. We definitely do want to do that. But what's the empirical basis? How do we do it when we're talking about things that are very hard to measure and very hard to trace? I don't last time I looked at this issue, which was several years ago, so could be completely out of date, there wasn't even good data available about identity theft, which is kind of the simplest thing to measure. And then how to measure various other sorts of harms, price discrimination, and things like that. What do we do? Okay, so those are my kind of comments and questions on the diagnosis part of the paper. Now let me boldly venture into the competition law part of the paper. The first thing I wanted to say about that is really just something about the structure of the paper, which is, besides the point about emphasizing concealed data practices, which I think is a really interesting and provocative contribution, the competition law analysis, to me, and maybe this is just because I'm coming at it as a privacy scholar, is the heart of the contribution. I don't think it should start on page 27. I think it should be earlier and more of that and condense the other part. This is just an organizational comment, because it took a long time to get to it, and I was kind of wanting to get to it. In terms of substance of that part, I really was intrigued by this idea of characterizing what's going on here with concealed data practices as something that has to do with the quality of the product or service. I really like that way of putting it. But I wondered, what is the difference between, how does that, besides its sort of evocative nature, how does it really matter whether I call it quality or whether I call it cost, price, charge? In my earlier paper, I called it a credence price, meaning that you're paying this price and you have no way of knowing what the price is. I think talking about quality might be a better way of making that same point, but I still would like to know the connection. And that also gets back to the same point that I made before, but I think is relevant to this. If we call it product quality, we still have to have some way to understand how big is this effect on quality, or how does it affect consumers? We know, I think there's no question that we're objectively sure that these costs and costs exist, but how do we figure them out? I think figuring out the value to businesses of the data that they collect is much easier to quantify. And so I'd be kind of curious to know what we can do with that, what can be done with that. In talking about that, it makes me think of a really sort of fascinating thing about the new California Data Consumer Privacy Act, which in the statutory language, there is a discussion, there is a provision that says you can only charge different prices as it relates to the benefits given to consumers by the data collection. In the proposed laws that the California Attorney General put out, having kind of realized this issue, I think those laws say, well, the benefit to consumers is actually the value to businesses. Literally, it says this, which is like kind of jaw-dropping, but I think it's because of this point. Okay, so then I would move on to say that, at least for me, and I'm probably not the target audience for the paper, I would like to see more about the effects on the competitive process. I mean, you already have it there. I would like to see that be a bigger part of the paper. And one question that comes to my mind on that is, how do we think about this as a competition problem if basically everybody does it? Every player in the market is doing this and can do it. So how do we think about that as a competition problem then? And maybe I was thinking maybe market for lemons might be a good way to talk about it. And then next, and I guess you already cued in that this is a big question for me or a big issue for me, but I don't know how to think about this from a competition and antitrust law perspective, but who are the consumers here and how should we be thinking about that? Should we be thinking that, in fact, the advertisers here are consumers and their interests matter? And I think this is particularly salient when we think about this framing of this in terms of product or service quality, which I think is helpful, but it's quite possible, and I think, even this I'm not certain of this, but certainly advertisers seem to think that all this data collection is improving the quality of the product that they are getting. So how should we think about that from a competition law perspective? I don't really know. I mean, should we be thinking of the impacts on consumers, but really we mean individuals, as part of the transaction or just sort of externalities to a transaction that's really with advertisers? And is the fact that we don't see any kind of self-correction here have something to do with the fact that this is an actual reflection of the demand for qualities of the advertising service from advertisers as opposed to some kind of exclusionary behavior? And sort of relevant to that is you have a discussion about how advertisers want lots of users, and I think that is true. But I think, on the other hand, they might prefer more data about somewhat fewer users. So they do care about number of users, but they care more about more data. There's some balance there. So I just would like more thinking about that analysis and how that affects the way you think about the competition law issues. There is a point you make on page 37 of the paper that I just really liked, and so I wanted to see it highlighted, and I wanted to see it made before page 37, which was that privacy policies completely fail as an effective means of comparing privacy quality. This seems to me just so correct and a really important point, not like entirely new, but a way of thinking about this that I haven't seen other people make, so I think I would highlight that point. And maybe relate it to the concealed data practices point and have more of that sort of angle on the diagnosis part. Then just one last kind of minor point, which probably isn't really for this paper, but you talk about the competition authorities as possible expert intermediaries here. I just wonder, this is not so much in the US context, but certainly outside of the US, nearly everybody also now has a data protection authority or a set of data protection authorities. How should we think about those two kinds of institutions in their relative roles as experts to be expert intermediaries? And are there any conflicts in trying to think of both of them in that way, or do they just supplement each other? And so with that, those are my comments.
Thank you. I am mindful of the time and a request, I won't name who posed it to me, to leave time and more time at the end for questions. So with that, I'd like to move on to our next panel so that we have some time at the end and have more discussion of Catherine's papers and others. Next up is an article by Professor Wendy Ng, who's a senior lecturer at Melbourne Law School in Australia, and her topic is the regulation and intersection of data, privacy, and competition in China. She's the deputy director of the Competition Law and Economics Network at Melbourne Law School, and she also has, in addition to researching competition law, particularly with respect to China and other jurisdictions around the world, she has practiced law in both Melbourne and New York. And then she is going to be discussing this paper with Professor Eleanor Fox, who probably I need to give no introduction about to this room, but I'll say that she's the Walter Derenberg Professor of Trade Regulation here at NYU. She is well known for her scholarship and her advice to governments, among others, about the development of competition policy and law around the world. And she's been awarded many recognitions and honors, too many to name. So with that, I'm going to hand it over to Professor Ng today.
Good afternoon. First of all, thank you to Danny, Harry, Ned, and the ABA for organising the conference and for the opportunity to present my paper. As we're all aware, debates about the intersection between data, privacy, and competition law have been very topical in the past few years. And I wanted to see how this debate might play out in China. Because the cultural, political, and economic contexts in which this debate would exist in China are quite different to that which exists in, say, the US. And in particular, China's internet and digital economy environment, which is where these issues have typically arisen, is quite distinct. So the way that data, privacy, and competition issues may be understood and addressed in China could be very different to how they might be considered in Western and developed countries. So the aim of the paper is to ground the examination of these issues against this background. So today, in my presentation, I'll highlight a few key aspects of this Chinese context and then briefly go to outline how data and privacy issues have been examined under the Chinese competition laws. And disclaimer, this paper is very much a work in progress, so any criticisms, comments, suggestions will be very much welcome. So first, what are the views and expectations of privacy in China? Now, there is a growing awareness of and demand for privacy. But the views and expectations of privacy are a bit different because of the cultural, historical, and political context. Now, traditionally, the notion of privacy was linked to the commitment and priority of the community and the state over the individual. And privacy is really about protecting one's own reputation in the community and that of their family. And these community-oriented roots still underpin privacy in contemporary China, even though privacy has been gradually evolving to a notion that is also based on the individual. The second thing to note about privacy is that the demand for privacy is largely directed at other citizens rather than the state. Now, China has not had a historical legacy of forms of governance where citizens have expectations of privacy from their government, especially where a strong state is at the core of those forms of government. Oops. The second thing is, well, what is China's approach to data governance and the internet? Now, data is incredibly important to the Chinese state. It's key for national security, political stability, and economic reform and development. And China, as you probably know, has long used various ways to collect and strictly control data. And the rise of the internet and other technological advancements has been a two-edged sword for China. On the one hand, the state has harnessed this explosion of data that has been generated through the internet and collected through the internet and other technologies to forward its national security and economic development strategies and objectives. At the same time, the internet also presents a challenge and a risk to state power. So therefore, it is a sphere that has to be controlled. So China views the internet as a territory over which sovereignty must be asserted. And internet security is also considered to be an integral part of national security. And third, well, you may have noticed that in both the discussions of privacy and data and internet governance, that the state's interests appear to be protected or favoured. Privacy demands aren't really directed against the state, and the data and the internet governance is oriented towards the state's interests and objectives. And this state-centric orientation is also evident in the personal information protection framework that is currently developing in China under the cybersecurity law. And this is the most comprehensive privacy regulatory framework in China to date. Now, under this framework, most of the obligations are imposed on the internet and technology companies, who have obligations both to consumers to protect their personal information and also to the state to provide assistance and cooperation to government departments. So that's the obligations on the internet companies. Whereas for the state, its access to and use of personal information remains largely unchanged and unencumbered. So this personal information protection regime enables China to accomplish two seemingly contradictory objectives. It responds to increasing consumer demand for greater data privacy protections. At the same time, it ensures that the state's continued access, use, and control of data remains unchanged. And this regulatory space is incredibly complex. There are multiple regulators involved, not just from the government side, but also from the party apparatus as well. There are also close relationships between the state and the private internet and technology companies that dominate the space. And the personal information protection system exists in the cybersecurity system, which means that in addition to privacy and data, you have national security issues, public security issues, propaganda, and industrial policy matters, and they can all come into play when you're talking about this space. So when it comes to data and privacy in China, there is a web of commercial, consumer, and state interests. Competition law could play a role in coordinating, balancing, and resolving this myriad of interests. And there are two key competition laws in China. Oops. The first one is the anti-monopoly law, or the AML. It covers typical antitrust matters. It focuses largely on the economic competitive impacts of conduct, and it looks more at the market as a whole. The other law is the anti-unfair competition law, or the AUCL, and it covers unfair competition conduct. And it focuses on the fairness of business transactions and business ethics, and it looks more at the relationships between individual businesses and single transactions. So whereas the AML looks at a more micro perspective, the AUCL is a bit more micro. And in my paper, I analyse how data practices, and privacy issues have been examined under these two competition laws. And I find that these issues have arisen under competition laws in several ways. First, I'm not very great at this. First, it could be as a result of competition over data or privacy itself. The second way is through looking at data and privacy as parameters of competition relating to other goods and services. And third, where the gain or loss of privacy or data is an outcome of competition or the conduct that is being scrutinised. Nope. Now, competition authorities and the courts have treated data and privacy in their analysis like any other asset or competition attribute. They've been taken into account where relevant to understanding the underlying competition and business dynamics and issues arising from the conduct, and the issues have been considered within standard AML and AUCL analytical frameworks. However, most of the cases so far have examined conduct that took place before the cybersecurity law came into effect in June 2017. And remember, the cybersecurity law brought into existence a more fulsome, concrete, and visible privacy regime in the form of personal information protection. And so I argue that the cybersecurity law will likely provide greater scope to consider data, privacy, and personal information protection issues within the ambit of these competition laws. And additionally, it might prompt the authorities to adopt a more synthesized and bolder and arguably more contentious approach to analysing these intersecting issues that goes beyond the competition law, the standard competition law analytical framework. Oops. So in conclusion, issues relating to data, privacy and competition in China must be explored in a manner that takes account of the wide range of commercial, consumer and state interests that are implicated, and in particular, two things should be kept in mind. First, the privacy and data framework are tilted in the state's favour, and second, privacy and data are also likely to give rise to issues relating to national security, public security, political stability and industrial policy. Thank you.
Thank you, Wendy. Eloise?
Thank you. Since you're right here. Yeah, okay. Wendy, I thought that was it's a very interesting and fascinating paper. Is there a feedback of that? Yeah.
Turn your mic.
Yes, okay. All right.
You can use yours. Wendy turned hers off. I think that'll take away the echo.
And how do you turn it off?
That's excellent.
All right, so I think it's a really, this is still feedback. I don't know. Yes, okay. I like feedback, but not that high. This is a really important area for exploration. That is how China deals with these problems and these intersections. Data privacy, competition law. I would also add consumer protection law, and I think this also relates to Catherine's statements about integration across the subjects that are implicated in big data. So let me mention a couple of things that I think might improve the paper, although it's already great. I think that it would be very interesting for you to talk a little more about China and state capitalism, even though you've talked about it. But the real difference that China's model of competition law as state capitalism can make a difference in the outcome of the cases. It's very that's number one. All right, now, number two, I wanted to talk a little bit more about the intersections of the data protection, privacy, and competition law, maybe consider protection. And number three, I wanted to say a little more about specific examples you might draw of data problems that are competition problems that has been surfacing this conversation, US, EU, and around the world, and see how China maps onto or doesn't map onto the analysis that we are seeing in various parts of the world in view of state capitalism and treatment of data. So on the state capitalism point, I think it's very interesting that you bring us through the history of how Chinese people consider what they're entitled to or not for privacy and the relationship with the individual and the community and the state. I'm very interested that the big players in big data in China are private. They're not the state. So that it's possible that you come to a conclusion that despite the state capitalism, because the players are private, it's just private rules that apply, and the state tendency of using intervening for industrial policy might not matter so much if it's just private. I think once you pose it that way, I'd be very interested in seeing the conclusion, like for Baidu, Tencent, and Alibaba, are the outcomes and the requirements basically not involving state industrial policy because they're all private, or because the state has so much ability to step in to get data from whatever company it wants. There is an overlay treating those companies as if they were partially public. That is state capitalism stepping in to get their own industrial policy preference for getting more data and having more ability for surveillance over people. Also, regarding possible state ownership, if there are SOEs that are involved in the big data area, are they treated differently? Are they allowed to take more data than under the cybersecurity? Is privacy protected less? All right, so number two, I want to say something about the intersection of the fields of data privacy, competition, consumer protection also. I think that you very helpfully have shown the intersections, and I think I would, and I support that, and Catherine has too, and I support it. And here, let me just say a word about how you might pick up and be a little more comparative about showing the intersections. And although you mentioned the German case, and Germany was really out front and has been in the cases in litigation, the case against Facebook, in which it finds an antitrust violation of exploitation using the data privacy regulation, drawing from the privacy regulation. I think that's an interesting example. It is on the field that this court has indicated some reluctance to have the three combined. We have to see what outcome that will be. An interesting other comparator, although it's for the future because we don't know how it can be working out, is the U.S. Federal Trade Commission, which has, of course, power over competition and consumer protection and some data protection to the extent we have data protection, and will our Federal Trade Commission cross some borders? And here I want to be supportive from your observations that crossing those border lines might be good. I think because there are some problems that arise with data protection and also data abuse. I definitely want to include data abuse in that analysis. I think it's very helpful not to be bogged down into silos and say, oh, no, this isn't an antitrust problem because we just analyze it under our traditional antitrust rules and it's free to consumers and we don't see consumer harm. I think that is a danger, and I think that if you get into the breakdown of the silos and you can see dissection, how consumers are deceived by all this data taken from us and we didn't get notice of it and we don't know what it's going to be used for, and we do know it's pretty valuable in the aftermath. So I think dealing with the issue as a problem that we see and not having in the first instance to fit it into a silo, that we would be better off. So third, as I said, I wanted to say a word about the usefulness of very specific examples. And here I would go to the antitrust analysis. And I thought that you helpfully didn't start by saying, these are the antitrust problems, we want to see how data protection fits into the problem, but we're starting from what is the data protection and what it isn't. But I thought before you wind up, you should come back to competition as center stage, because it's very helpful in comparing, for example, how China treats the BATs, the Baidu, Alibaba, Tencent, and comparing that, say, with how the European Union, where the most aggressive and interesting cases are being brought and resolved, what did the results say was. So if you start out much later, after you have your introduction and evolution, if you talk about very specific problems that are antitrust problems and see whether data protection, data abuse, consumer protection, deception, fit into it, I think you can have something more concrete. So there are about 5 sets of problems. One set is exploitative abuse. It's usually not a U.S. antitrust problem because we don't have a statute that says that this raising prices or taking too much, I mean, the price of picking our data fits in there. We don't have a statute that says excessive pricing is bad, but this definitely relates to EU and the rest of the world, and maybe our FTC is edging up to this problem of exploitation of data. It could be exploitation that these companies are using our right to privacy, and it can be exploitation because they're taking so much valuable data without telling us about it. And we might start with the German case about exploiting. And the other is exclusionary. And there are various exclusionary problems. This is more abuse of data than protection of privacy, but where Facebook, for example, will cut off normal data use by a firm on the platform because it's a rival and doesn't want the rival to get too big. And so that's a second kind of problem. The abuse, the use of data to abuse. Another is the use of data, just appropriating other people's data to make the best thing and actually beat out those who are on the platform. So Snapchat is one example, I think. And also privacy protection, and this has been raised by good paper writers, on competition. If you have, for example, a merger of firms where the harm is you're eliminating their competition on terms of privacy. That is definitely a harm to competition. As some of you have mentioned, when I'll be a little more expansive in talking about what is a harm to competition, in my view, it's definitely a harm to competition, and I think a lot of people's view. And then if you go through this line of what are the antitrust cases and problems, and how does China decide them and compared with how does EU decide them, and if you want to be a fortune seer, how will US decide them if it finishes the investigation and goes to the next step? Thank you very much for your paper.
Thank you, Eleanor. So, we'll now turn to our third paper, which is authored by Garrett Johnson. It's called Privacy and Market Concentration, Intended and Unintended Consequences of the GDPR. And Garrett is an assistant professor of marketing at the Boston University. I'm going to pass the clicker down if you need it. At the School of Business at Boston University, he focuses on internet marketing, including online display advertising, the effectiveness of it, and related privacy issues, among other things. He has authored a recent paper, I think, that's called When Less is More, Data and Power in Advertising and Marketing Science. And he is going to be discussing his paper with Professor Ananda Ghosh here at the NYU School of Business. He is been identified as one of the 200 top thought leaders on big data and business analytics. He's the director of the Masters of Business Analytics program here at NYU Stern, and he teaches courses on social media, digital marketing, business analytics, and IP strategy, among other things. And with that, I'm going to hand it over to Garrett.
Well, thank you very much. Thank you to the organizers. I'm looking forward to meeting some new people today and encountering some new ideas. So today I want to talk about concentration and the impacts of the GDPR. This is joint work with Scott Schreiber at the University of Colorado. And I also want to thank the organizers for inviting me here, because the older I get, the more I appreciate being part of these sort of rising stars, older next generation sessions. So why are we interested in the GDPR? The GDPR is a landmark piece of privacy regulation that impacts an entire continent. And what's more, it's inspiring change in privacy laws worldwide, including the policy discussion here in the United States. So we want to try to understand this policy better. One of the challenges we face in studying this regulation is just how long, how complicated, and frankly, how vague it can often be. So in today's presentation, I want to talk about one principle of the GDPR, which is data minimization. And there's many elements of the regulation that incentivize data minimization, and that effectively increases the logistical costs and the legal liabilities associated with processing a consumer's personal data. So this should naturally have the consequence that we should see less data processing, less data collection, and less data sharing. However, this may have the unintended consequence of affecting competition, and there's several reasons for that. On the consumer side, this regulation tells firms in the internet space that they should be getting consent from consumers, and that consent should include the list of firms that are going to be getting consumers' personal data. Now, if you have to show a list of firms to consumers, that incentivizes making the list short and including firms that the consumers recognize. And these two factors would be anti-competitive. On the firm side, there is an age-old concern that regulation can be anti-competitive if there's economies of scale. That is, larger firms have an easier time complying. What we're adding to this discussion is, in the context of B2B vendor choices, if the law tells firms that you should share data with fewer data partners, then one possible unintended consequence of that is that the firms would prefer to work with the larger vendors, either because the large vendors offer a better product or because they are more in compliance with the law. Now, this is an empirical paper, and we're going to study it using the enforcement deadline of the GDPR in May 25th, 2018, as a natural experiment. So the data that we're going to use is the internet and websites' use of various technology vendors to help them work their sites. So when you visit a website like this one, your browser is going to work with the first-party domain, in this case mcall.com, to provide content. But in addition to this, your browser is going to operate with dozens of various third-party domains belonging to vendors that the website has decided to engage in order to perform several services. So most often this is going to be advertising. Most of these vendors are going to help monetize the content of the site. But there's other uses such as on-site analytics, so understanding the audience better, social sharing of content, as well as just providing content like fonts, video hosting, various APIs, and code that helps websites run more efficiently. Now, what's exciting about this is that traditionally, firms are not going to broadcast who they're sharing your personal data with. But in this setting, we have an exciting opportunity to be able to quantify that and understand these relationships because they're being outsourced to the browser and we can track them. So this is effectively the exercise. I did this for 27,000 websites. And I ran a piece of specialized software developed by a researcher at CMU that records all the third-party domains that your browser encounters when you visit a website. Now, in order to simulate the experience of an EU user, I'm going to use a VPN service to make myself look like I'm French. Oui, oui, oui. In order to be a website in my data, you have to be among the top 2,000 sites for any of the EU countries, or the United States, Canada, or globally. So collectively, this represents 28,000 websites, 97,000 of which we're able to repeatedly crawl data for. And I do this data crawling throughout 2018. So to get a little bit of sense of what are the web technology vendors in the data, well, the largest one here prior to the GDPR is advertising. So on average, websites are engaging 4.35 advertising vendors. The next largest is hosting, which does services like video hosting, video content hosting, font hosting, APIs, and computer code to help the websites run. The next category is audience measurement. The large company in this case is Google Analytics. So this helps websites understand their audiences better. And then the fourth is social media, which allows for social media content sharing. And then there's several other services, but as you can see, they're a relatively small part of the data. So what was the impact of the GDPR on these vendors? Well, right before the GDPR, we see that websites were on average engaging 14.5 of these vendors, but within a week, that fell to 12.5, and that fell by about 15%. Now, interestingly, I had expected that as firms were scrambling to comply with the law, that we would continue to see a downward trend. But in fact, what happened is that there's a bit of a bounce back 2 weeks after the GDPR, and then there's a gradual trend upwards to the point where we're right back where we started prior to the GDPR. Now, it's hard to fully account for that trend because this is a very dynamic market. I personally believe that some of it relates to the lack of enforcement by regulators in this space. And so we're going to focus on the short run drop, which is 1 week post GDPR, where we see the most movement. And I think that that's actually speaks generally to where the policy could arrive in the future because, again, there hasn't been enforcement, though the regulators have said they plan to enforce this law in 2020 in this sector. So we see an aggregate reduction of about 15%, but when we look into the different categories, we see pretty much an across-the-board reduction. So the largest category is advertising. It falls by 24%. The rest of the categories fall by around 10%. And the exception here is privacy compliance, and it makes sense that after a privacy law, we would see websites using more privacy compliance firms. So the story here is not that the web technology firms are singing a song and dance post-GDPR. The pie is definitely smaller. Instead, the question that I'm asking in this paper is, do the large vendors get a larger share of the smaller pie? Do we see an increase in market concentration? Now, in order to quantify this, we're going to use the Herfindahl-Hirschman index, which is the sum of the square of market shares. And HHI is going to vary from 0, which is the case of perfect competition, all the way up to 10,000 points, which is the case of a monopoly. So more concentration is a bad thing. And to define market shares, we're going to use the reach, so the number of sites that a vendor use, and we're going to define their relative market share as the sum of, as their market share as a ratio of the total reach of their competitors. And so we have a relative market definition, and that means if everybody goes down by the same percentage, this isn't going to move. But if the larger firms are getting a bigger part of the smaller pie, then we will see a higher metric. So what do we see? In the top row, we have the aggregate HHI for the whole industry altogether. It increases from 146 to 171 for an increase of 17.3%. Once we dig into the categories, we see that advertising, which represents 50.2% of web technology vendor relationships in the data, the HHI increases from 348 to 436 for an increase of 25.3%. Now, the next top three, the second, third, and fourth category on the list increased from between 2% and 6%. And thereafter, the relationship varies. So sometimes it's negative, sometimes it's positive. But in aggregate, the concentration increases. And for the top 4 categories that make up 94% of our data, we see an increase. So now I want to talk a little bit more about why this is going, how this is happening, by cutting the data in 3 ways. The first thing I'm going to do is I'm going to separate the companies that appear to be, the vendors that appear to be using personal data versus those that don't. And in that categorization, we see that those that use personal data see an increase in concentration of 24%, versus those that don't see an increase of only 5%. So this means that the place where we think the law should be doing the most work is actually doing the most to increase concentration. And this also means that an unintended consequence of the law was to increase the concentration of the pool of personal data that these firms have about users on the internet. Now, the second cut we look at is the role of consent. And we do this by separating websites by whether or not they ask consumers for their consent. And here we see that the increase in concentration is essentially the same, 18% versus 17%. So we don't think that this is playing a role, and actually the reason for this is pretty intuitive, because though companies are supposed to list the various third parties that they work with, it turns out that they bury that in the consent menu behind several clicks that very few consumers would actually ever see. Finally, we look at the role of the top 2 companies in this space, which are Google and Facebook, that represent over half of digital advertising spending. And here we see in the full marketplace that there's this increase in concentration of 17.3%. That's what I showed you on the last slide. But once we drop these 2 big whales from our data set, there's actually a decrease in concentration of 6.2%. So it seems these companies are playing a very important role. One way that you can think about our result is in terms of the old adage, nobody gets fired for choosing IBM. Here I think we've sort of discovered the Google and Facebook version of that adage. So in sum, we have this important policy that we care quite a lot about. It did have the intended consequence of reducing the amount of data sharing online, at least in the short run. But it had the unintended consequences of increasing the amount of concentration in this sector. Now, this is important because we have theorized that there is this tension between privacy policy and competition in the past, and this is the first paper to show that empirically. Now, we also showed that this is not an iron law of the universe. It doesn't always hold, but it holds in aggregate, and it holds for the largest categories. And finally, we have some sense of how this is happening. We know that the big 2 companies are playing a key role in this, that this is happening in the pool of personal data that regulators are interested in protecting, and finally, that consent does not seem to play as much of a role as expected. So I'll leave you with a meme summary of the paper.
Thank you, Garrett. And I'll let you comment.
Okay. Well, first of all, thanks for having me, Danny. When I was asked to discuss this paper, I was really thrilled for two reasons. One is, I know of Garrett's work from the past, and he does really interesting work. And secondly, because the topic of GDPR is very personal to me, because I've actually spoken against GDPR in several forums of these kinds. And I have a background at the intersection of business and computer science. And so sometimes that thinking takes me to think about the implications of these privacy laws on the algorithmic aspects of a society. And one of the reasons that I've always been somewhat disappointed with the final execution of GDPR, the way it was finally carried out, is it imposes some really severe restrictions on what companies can do. And I'll give you a very simple example. There's a particular clause in GDPR which is and can be interpreted the following way. The clause basically says, suppose you've got two people who are surfing on Amazon, okay? Now one person gets to see an ad for the Nike shoe, and another person gets to see an ad for the Adidas shoe. So GDPR, and this particular clause in GDPR, empowers each of these consumers to go back to the platform and ask for an explanation as to why he saw an ad for Nike and why I saw an ad for Adidas. Okay? So in the world of AI, my background, my training was also in machine learning. In the world of AI, we refer to this as explainable AI. So the problem with the world the way it is today is we are really quite far from the world of explainable AI. It's a huge task to impose on tech companies to be able to tell their customers why they're seeing, something versus the other thing. So long story short, some of us who work in this space, we had predicted that GDPR would have very unintended consequences, and so I was very sort of pleased to see Garrett's work in this space. So I am basically going to summarize, what Garrett has done, give you again some background, and then maybe leave a couple of thoughts for future reference for them. Okay, so what's the motivation that Garrett and Scott have? They're basically asking a very fundamental, very important question. Does GDPR and laws like GDPR, do they have unintended consequences, one of which is market consolidation? Okay, so yes, that's what they find. The GDPR has minimized essentially the collection of personal data, but that has led to increased consolidation by the larger firms. So in this case, it's Google and Facebook. Now, the intuition, even before you look at the data and the modeling, if you look at the intuition is also very powerful, right? There's at least two reasons why this can happen, and Garrett referred to them. First of all, large firms have the technical and financial resources to comply with these new regulations. And again, sort of going back to my analogy, if people start going back to Facebook and Apple or Amazon and Google and asking explanation for why I get to see this ad or that ad, they might have the power eventually in 5 years' time and the resources to comply with that and give an explanation. But the smaller startups won't have, so they have no chance of, duking it out with the bigger platforms. Okay. And second of all, the other intuition is that larger firms have a stronger brand equity, so people might feel more comfortable, giving up their data. Okay, so that's sort of the intuition here. All right, so I think it's, it goes without saying, it's a very important and a very nuanced question because it can have several countervailing effects. I thought the question is really important, not just because of the effects that they show in this paper, but it has larger economic outcomes as well. What happens to consumer behavior, for example, what happens to company revenues. And I'll offer a couple of thoughts on that later in this discussion. So the other thing I like about this paper is, it's simple. The method is very simple but very effective, right? So essentially, what they're doing is a before and after. So those of us, if you have, done these kind of studies, and it's not very easy to find a clean intervention, right? And in this case, it just turns out to be a very nice intervention, very clean. Also, for the most part, it's exogenous, right? Companies don't really have a say on what the GDPR, when the EU will actually release it, right? So there's a little bit of forward-looking thinking that you can anticipate, but it's you can still consider that reasonably exogenous. Okay. So in terms of the data setting, what they did is they essentially examined 27,000 websites. It was very cleverly assembled, and this part of the example where he said they use VPN masquerading as a French customer, right? And that's part of the the cleverness that these guys came up with. And it's important in this paper, right? Sometimes you come across paper where just trying to be clever for the sake of it, but in this case, it's actually important because you have to do that. So, and within a week of GDPR, this paper shows that there's a 14.9, almost 15% reduction in the number of web tech vendors, right? However, it dissipates by the end of 2018. So there's a short-run effect, but the long run, and so on. The other good thing, other really nice thing about this paper is when you look at concentration, right? So Jared talked about HHI, the Herfindahl-Hirschman index, but they also have two other metrics, which I like the fact that it's a nice robustness test. They use concentration ratio. They also use the head-to-head win metric. And collectively, basically, the results are robust, showing that there is a 17% increase in concentration. And mostly it's concentrated across these 4 categories. So like 94% of the effect is within advertising, hosting, audience measurement, and social media. Okay, so that's those are the specific quantifiable insights. So what are the overall takeaways? So here's a few, right? So clearly data sharing among tech vendors is going down, and concentration of online personal data is increasing, right? So those effects are very clear. The third effect is that the relative share of Google and Facebook has gone down. And one of the things I liked about this is that it's not like the GDPR will always lead to an increase in concentration. Yes, it does it for the top 4 categories, but not always. Okay, so that makes a lot of sense. It's nice to see the intuition coming out true in actual data. So what's really going on, right? Basically, what they find is that the underlying mechanism is that Google-owned vendors, their market share increases from 29 to 32%, right? And Facebook-owned vendors, their market share goes from 3.4 to 3.6. So those are the 2 primary sources. Okay. I believe they also, looked at the issue of processing of personal data as a likely mechanism, in addition to the fact that the larger vendors are getting a larger market share. Also, they ruled out consumer consent as a possible reason. So I believe the paper shows that, consumer consent doesn't have a very strong impact. Okay. And I think you guys did it through a consent management platform. So that was nice touch as well. So essentially the story really holds, right? Like everything fits nicely. It's and there's really it's hard to find flaws in this paper. So it's very neatly done. Okay. So I have a couple of thoughts. Again, I know that for us wish lists, it's always easier to wish for things than actually get it done. So if I personally get my hands on data, I would love to explore, for example, what the effect of these GDPR-like laws would be on advertisers, right? So here's the context. So these guys show, and very convincingly, that Google and Facebook's market share has gone up, and some of the smaller vendors are getting hurt. So that makes me think, okay, this is what we had predicted. Those of us who are critical of GDPR to begin with, we had predicted this is going to happen. Let's see what it does for the companies. So, for example, what does it do to the cost that these advertisers have to pay? Now, as market concentration increases, are they having to pay a higher cost per click or CPM, cost per impression to Google and Facebook? In which case, again, the bigger platform benefits, advertisers have to shell out more. But at the same time, if the ad effectiveness also increases, right, then there's a little bit of yin-yang. Yes, you're paying more, but you're also getting a higher bang for the buck. The ad effectiveness can increase if the platform concentration leads to them having more data about customers, right? Then their targeting gets better, right? So if more of them, it's just 2 companies handling 90% of the world, they have more data, so their targeting gets better. So the return on investment for the advertisers can go up. So you've got this very nice countervailing effect that would be great to study. The other thing is I also personally like to study consumer behavior as a function of tech intervention. And so it'd be great if we can examine, for example, what happens to consumers after these privacy laws are put in place. Are we changing our browsing behavior, for example, right? Are we changing the way we agree to sharing data or giving consent? What happens to publishers who make money by posting, by having ads on them, right? So There might be effect if our browsing behavior leads to a change in web traffic patterns, that'll have an effect on publisher revenues. It could also affect the revenues, obviously, of e-commerce companies, and so on. And so the last one, of course, is if you guys have studied this so well, might be interesting to start collecting data on CCPA and see what happens before after. So those are just some thoughts. And again, like I said, it's easier to propose, obviously, but if you get a chance, love to talk to you more about this. Thank you.
Thank you, Ananda. I'm going to hand it over now to Jay Himes to give his thoughts and feedback on all three of the papers, and then we'll have some time for questions.
Okay, I'm going to do Professor Kemp's paper first. I do agree that I think it would be good if you got the competition conclusions into the paper earlier. And I think overall it would be good if you embellish those competition effects and do it, I think, in terms that people are used to seeing. You do a very good job on laying out what you call hidden or concealed data practices and how they're operating. And effectively, I think of these things as creating moats around the already existing barrier to entry that's created by the network effects. And those moats are both affecting the ability, as you point out, of competitors to be able to compete. And by the way, I put aside the notion that we're going to seek competition on privacy. I think that's totally illusory in the environment we currently have. I totally agree with you that privacy policies are uninformative, that there is no effective consumer choice being made there, and you can't really, particularly when access to a site is conditioned on clicking through the non-negotiable terms. So you've got real effects on ability of competitors to compete once there's tipping. You've got, as I said, the moats that also encourage consumer lock-in. You have no, of course, regime here of interoperability. That's all reinforcing the lock-in that comes from, in part, I think the exploitive conduct over consumers. And it's hard to think of this, in U.S. terms of monopoly maintenance, but because the market definition is really one that's squishy, and we don't have really good tools, I think, to come up with it. But you can talk about it in terms of market power, enhancement of market power, and maintenance of market power. Those are the overall, I think, linkages between the data collection practices and competitive considerations. You could perhaps posit that an abuse standard would be easier to understand. And Harry probably liked this because he thinks we need an abuse standard in the U.S. So you'd get an extra, little credential there if you could cite him somewhere. But overall, I really like the paper. I am one of those people that does believe that the privacy collection and use activity that we're seeing has very serious competitive implications, and we can't just bucket it in some sort of consumer protection place. And I think as well, your concept of attack area, I don't read a lot in this area, and I don't know if that's your concept or something you borrowed, but the idea that over time the attack area gets larger, and it's not even an attack area, sometimes it's just an inadvertent failure of the system that causes the security breach. But I think that's a really good concept and one that people can understand, and certainly well, that's a very real cost to what we're seeing in this data collection, use, and distribution. So, as I said, I like that, but I would emphasize the competitive effects more and earlier. Okay? All right, Johnson Shriver. I'm gonna. It's hard for me to go up against two university professors, but I'm not.
Pretty nice.
Okay, well, I agree that the intuition, of GDPR affecting concentration in a way that increases concentration is, there's a certain intuition to that. It makes a good deal of sense. So the question is, are you really getting at it with this empirical exercise? And I don't think you are, is the bottom line. So let me just use the advertising effects as an example. And you're going through a counting exercise. You're counting what happens when you navigate to any of these 28,000 websites and there are reaches back, you call them interactions in the paper, and you're counting the interactions back to all of these vendors. And the vendors are, of course, all bucketed. Some you said are advertising, there may be hosting, there may be user statistics, that sort of thing. Well, let's look at advertising, because your calculation before the GDPR for what you say is an HHI is 348. After the GDPR on a short-term basis, it's 438. Now, you also told us that Google and Facebook are the dominant advertisers. An HHI of 348 is not going to bother anybody. I mean, we never have markets that have HHIs like that and worry about them. But you've got 165 vendors in the advertising market. Well, and all you're doing is counting every interaction as equal. So an interaction, a reach back to Google is no different from an interaction back to some nondescript company, or maybe a company that isn't even functioning anymore on the website, but you're counting it. And you're coming up with market shares on the basis of that count. The two-firm concentration ratio in your chart for advertisers is 18.7, or essentially 19%. That's pre-GDPR. Afterwards, it's 22%, 21.7. That's the two-firm concentration ratio for presumably Google and Facebook. I mean, I could be wrong, but I think Google would pay you a lot of money if you could demonstrate that's their market share in a really well-defined antitrust market. If these numbers seem on their face improbable, you have to ask what's really going on here. You're measuring percentages of reach, and you're doing an arithmetic exercise, but I don't think you're measuring concentration in any way that antitrust lawyers, academicians, or other people are really thinking about. And it's a mathematical exercise of counting reach, and that troubles me that it's being presented in terms of HHI and concentration, which for those of us in the antitrust community, have a certain content. And the content just really, in my view, isn't there. I can't do much with the China paper, frankly. I thought it was very interesting. You've got a sort of moving target because the anti-monopolies law now is changing. You don't have a lot of case law, and you mentioned the case law you have even predates the cybersecurity law, so it's hard to know what to make of it now. I found it interesting, very informative. I can't criticize it, honestly. I do have to wonder and maybe this harkens back to things that Eleanor said, given the cultural setting where the state is emphasized over the individual, whether you think that there is any way in which development of privacy protections could occur in China in a way that, or whether any development of privacy protections, the way we think of them in the West, could occur in China, and who would drive that kind of change? It's hard for me to imagine that that would happen, and that at least in the current environment, what you would have is the primacy of the state, and the state ultimately determining how the intersection between privacy, data protection, competition law is actually going to be allowed to operate.
Jay. Why don't we open up for questions, and obviously if any of our other discussants would like to weigh in on other papers, we welcome that too. Any questions in the audience?
I'll go again. I thought the papers were really interesting. The debate between the economist and the lawyer, that goes on in my home every day of the week, so I get it. I've been playing over in my mind for the last 45 minutes the issue of tort law. And tort law is the basis for all these other laws we talk about. And at first I was very taken with the insurance story. But that insurance company would have the right to ask me that information if I wanted to buy insurance from them. So even though I was really upset about it, that my data could be scraped and sold to the insurance company, and then when I go to the insurance company, I don't know why they are being punitive to me. So, because they've gotten access to information about me that I didn't give them. So that is a possible contractual question, a regulatory question, a legal question, I'm not quite sure. On the effects that Jay highlighted, maybe intentionally Jay, I don't know, of sort of the first step of the damage to us online, of having our identity stolen and things like that, I think that's easier to think about a case law, a case kind of approach, or regulatory. I think from a class action perspective, it is also more interesting. But I think for the next generation, I get very worried about class certification in these cases, because a lot of these kids, and surveys would show it, are more than happy to have all their data go out to the world, they don't care. And so then the question becomes, do we educate them, or are there real harms that they would recognize and be concerned about?
Yeah, really interesting points. And I, just to start with your first one about the insurance company and whether that's a contractual matter and whether it's any different to an insurance company saying to you, as they inevitably do, answer these, 150 questions about your health. I think it's quite different because this kind of tracking and monitoring of your health on a second-to-second, minute-to-minute, day-by-day basis that can occur with a wearable device is not something that we could actually provide to an insurance company ourselves unless we had kept a log of that over time and then somehow then transferred the entirety of that information. These happen to be wearable devices that are provided by insurance companies themselves and on a real-time basis can monitor the health of their customers and therefore adjust what they offer their customers over time. And my problem with that is partly that this is concealed from the customers themselves and sold to them as this is just helping you to be healthy when it can be used against their interests. And partly to address that question of whether these are just subjective preferences, as a number of people have argued, that there are a small group privacy-sensitive consumers who worry about these things, they can take care of themselves by using privacy-enhancing tools, and the rest of us can get on with making these fair bargains with the companies we deal with. I don't believe that's the case because, on the one hand, I think these are objective harms in that you, by having that information disclosed, can be charged higher insurance premiums in this example. And on the other hand, cannot protect yourself ultimately, as Kathy has demonstrated in her freefall paper quite extensively, that ultimately using the tools we have available to us, we cannot find out the full extent of the disclosure and the consequences or guard against those things. So I think it helps to regard it as that objective detriment rather than the subjective preference in that way. As to the willing disclosure by a certain generation, often people point to millennials. I think there are some aspects of providing content on social media, for example, where there is an open transaction taking place. It's clear what information is being actively provided. It's very often the passive collection of information, the constant tracking across the web, across different devices of people's location, which is unseen and very often unknown and later aggregated and used to create inferences to a completely different effect.
I have a question for Wendy. Very interesting presentation. So there is a huge appeal to accessing personal information, both on the competition side and on the privacy personal information markets. But China, I think, represents a unique case because they have social credit, an incoming social credit system, which, leaving aside all the disadvantages, does offer a lot of transparency about individuals and about their personal information. And to my understanding, it's also kind of the combined mission of the government and private companies. So I wonder, against the backdrop of social credit and the amount of information it provides on individuals, do you see any kind of decrease in the appeal of personal information or business models that are based on using personal information in Chinese markets?
Social credit system is highly contentious. It's also, I think, been spun in a way that is quite misleading in Western media and things like that. It's spun in a way that seems a little bit more Big Brother than it really is. Technically, there's a scholar at Yale that looks at this extensively, where if you look at all the regulations, it's actually not that much different to what was existing previously, in the sense that it's kind of like a credit score. It collects information that is available from your banks and things like that, and it does consolidate it in a more concrete way. And there are a number of different companies that provide different types of credit scores. Well, social credit, depending on the government. So it could be provincial, could be local, depending on the industry, etc. In terms of whether or not there's whether or not there's a decrease in the demand for that information, or?
No, what I'm saying is that social credit, again, leaving aside the disadvantages, is transparent. The system, to a large extent, how the system works, what goes
Not
into
really.
it. Not really.
Not really, no. Not in the way that it operates in China, no. So in that sense, there is some resistance to it. At the same time, if there is some sort of transparency, but also the way in which they reveal that information is quite damaging. For example, I've heard that in cases where, at the end, how we have movie trailers and things like that here. Instead of playing a movie trailer, they'll just play a list of people in the city that have a bad credit score, and so that shames them into going to pay their debt. And so in that way, it's not very fair, or people have not necessarily consented to the way in which that information is revealed. So yeah, I don't know, I don't like it.
Recently, they said that it was...
I'm trying to say that it's Okay,
Yeah.
what I'm saying is that it does provide a lot of information that is not traditionally provided about individuals.
Yeah.
And I'm asking whether that changes the amount of demand for personal information, because that's a very specific way of sharing information about individuals that companies now know more about. Everybody knows more about.
Oh, I guess it depends on who you're, like, is it the demand from the consumers, demand from businesses, demand
My
from,
question was about the company.
about the companies? Well, companies would, well, they collect all sort of information, so I'm not sure the amount of information that they collect is different. It's just the way in which it's revealed and the way in which it is shared with the public and also the state.
Can I just chime in on that one?
Sure.
So just some background. I've actually worked in various capacities with Alibaba and JD and China Mobile and a few other tech companies over there. So yeah, one clarification that's often useful to mention is it was not the government that initiated this social credit scoring. It was the companies themselves, right? So it was the bad companies along with a few other unicorns that came together. The other thing is, to your question about whether we see more or less use of personal data now, we definitely see more use. And part of the reason is that these tech companies in China, they are really, really good at achieving this trade-off between personalization and privacy, in the sense that, sure, we have more data about you, but we can pass back more of the benefits back to you as consumers in the form of economic convenience, economic discounts, all our prices, coupons, ads, etc. So my first foray in China was about 10 years back, and the most recent one is now. And so over the last few years, we've definitely seen more use of this. And more importantly, there is more support from consumers with this policy as opposed to what the Western media might say. So we as in collectively the Western media, we trivialize this, but there's a lot of upside to this as well. And a lot of that is passed back to consumers.
Any other questions?
I actually, sorry, I didn't want to interrupt a question. I just wanted to
It's
make
only
a.
Harry you can interrupt.
Yeah.
Okay, well, I wanted to make a somewhat piling on comment on Garrett and Scott's paper, or maybe ask a somewhat provocative question, which is, so one way to look at your paper is you've shown that there is this increase of concentration after the GDPR. But another way to look at your paper is you've shown that over the long run there is no increase in concentration after the GDPR. I'm not sure why I should care what happened 1 week after the regulation was introduced. And another way to potentially get at that is to ask, what if I compared this to some other sort of regulatory regimes that are put in place? Is there anything different here, or is this just kind of normal? You put in a regulatory regime, people scramble around, coping with it for a little while, and then things kind of go back to normal. So that's my question.
Oh, sure.
Well, thanks for the question. I wanted to begin by talking a bit about Jay's point. So the challenge for those of us that work with data rather than anecdote is that we can only work with the data that we're given. So obviously, I would like to know the total amount of money that's going to these 160 different companies on the web. If anyone could provide that to me, I would be happy to redo the study. Absent that, I have to do this counting exercise, as you describe it. And I think the counting exercise, if you think about this for a second and you think that the share of money that's going through these connections is staying roughly constant before and after the GDPR, if you're getting this directional movement in concentration, then you would get the same thing with money. And so it would have to be that the money is changing significantly enough to offset that. And I think that just would be a misreading of the situation, because the same economic forces that drove the publishers to stick with a large company, you can bet is definitely happening on the advertiser side. Like Google is doing quite fine with the relative share of money that's going to it post-GDPR. So I would expect actually the estimates to be even larger if you were to look in economic terms. So I think that's really important. And then the question that you just brought up was the issue of the short-run nature of our effect. That's obviously a challenge. I would argue that we have yet to see proper regulation of the enforcement of the GDPR in this sector. The regulator has come out and said that you need to get affirmative consumer consent. It needs to be just as easy to say yes as it is to say, or say no as it is to say yes to this form of advertising. And the reality is that the status quo has persisted. Companies put up pop-ups. They say press OK to continue, or do a bunch of work to stop things. That's been allowed to persist. There's not been any enforcement of companies in this space, and so the question, the hard question is, what does the market look like post serious enforcement of the regulation? And I would believe that post 2018, when things have pretty much gone back to where they were before, is not where you should be looking for your answers.
Harry? We're over time.
I'll bring it up in the next round, and I'll just ask it then.
Great. Well, thank you, everyone, for your very fine papers and for the discussion today. So thank you very much.